morning. My name is Michael Green. I'm the clerk of Green's List. Our topic this morning is damages, relief, as you know. Our chairman is David Levin, one of the commercial silks on our list, and so I'll introduce David to you to commence proceedings. Thank you.
One thing as a practitioner one often experiences is clients who come to chambers and explain their problem, and they've got a very good case. But what they really want is an effective remedy. They're not really interested in being in a footnote in the latest edition of the Law on Contract or an interesting article in The Age about their litigation. They want a solution, an effective solution. And of course they also want their litigation to be cost effective and for them to be awarded, if they're entitled to it, such interest as the law provides under Section 58 or Section 60 of the Supreme Court Act or the Penalty Interest Rates Act or whatever. As practitioners, we've all seen cases where within a very short time of the commencement of the battle, we as lawyers, and almost invariably the clients, see that they're not actually fighting about the critical issues at all. They're now fighting about the cost that they've spent, or the cost that they fear they might have to pay to the other side. And so the battle moves from the real issues to the entitlement to costs or the entitlement to interest. All practitioners have to know the opportunities and the problems associated with obtaining different forms of relief. And they need to know about these matters at the outset. They ought to be, yes, you've got a bloody good case, but there just isn't any effective relief, or it is extremely unlikely that you'll be able to prove the damages that you think you're entitled to, or you won't be entitled to a declaration in the form that you believe you're entitled to. Elizabeth was a senior associate in litigation and dispute resolution at Allens, where she was involved in all stages of proceedings in most of the superior courts. Her practice encompasses insurance law, contractual claims and regulatory compliance issues involving the ATO and ASIC. And she has also worked on secondment in a commercial area and gained an understanding of banking law and commerce imperatives. She was associate to Justice Neve in the Victorian Court of Appeal before she came to the bar. And so without any more ado, I'll introduce Liz Bennett to you. Thank you, Liz.
Morning everyone, and thanks for coming out on this early cold morning. I have a broad topic and then my friend Simon here will get into a more detailed and arguably more amusing and interesting sort of area. But because it is quite broad and it does range across a range of areas, feel free to ask questions as we go along if something piques your interest, because this really is a potted history of the areas of interest that I have, really, in commercial disputes and the sorts of matters that have come to my attention over time that have piqued my interest and I find interesting. And I think that the way that we began today is really the starting point, and that is what are we trying to get out of it? And it does happen quite often that you have a client who is very keen on the principle involved and who feels very aggrieved, and if we can't find a way to translate that into damages most often, sometimes injunctive relief and sometimes declaratory relief, but most often damages, then we have to be very careful about how we proceed. And really, so I'm going to start off quite basic and we'll move into a few different discrete areas, so feel free to throw in some questions. I always think the best place to start with damages is what is the aim of the damages themselves. It tells us a lot, and when we have novel problems that we come to, starting back at that initial point of what is the aim of the doctrine itself often yields the answer. So, for example, And these are quite trite points. In tort, the aim of damages is to put you in the position you were in before you were injured, or before the tort was committed, more accurately. In contract, to restore the position you were in before the breach. And in equity, well, I haven't been able to distill a particular rule. I've done my best by saying it's compensatory and awarded in support of legal rules. I had to restrain myself from a section on Lord Cairns Act in this paper because it gets a bit convoluted. So I haven't really touched on equitable damages, but I assure you it's fascinating. So they're quite the simple propositions that we all know and love from first year university, but they get quite complicated, and they're also the starting point in terms of identifying the right loss and taking it to the court and having it supported by the proper evidence. A lot of the time people assert an entitlement to damages but don't have the right support, and it's extraordinary the difference it makes to turn up with really good evidence. I've noted, just by the way, that while we tend to conflate contractual damages and tortious damages, there do remain a couple of areas of difference. They continue to allied to a reasonable degree, and you'll see actually I have fallen into the sin that I warn about in paragraph 5 I've actually done later on, which is to keep an eye on that difference. So don't think just because you're dealing with damages that all cases to do with damages are always relevant. You do need to discern when we're talking about contract and tort, and quite often there's going to be a significant degree of overlap. I've started off with contract because that's frankly where I have the most experience, and so that gets the bulk of the airtime in the paper. And the most obvious point is we're looking at compensatory damages most of the time. And the key point there is, once again, the court is going to be looking to make sure you don't make money out of this. They're looking to make sure you get back what you've lost, putting you in a position you would have been in but for the breach, but not in a better position. And that's quite an interesting, once again, evidentiary point, because you'll often be faced with somebody saying they're doing better out of this, and you need to show why that's not the case. You need to meet that windfall argument, often through evidence. And the classic statement is set out there in paragraph 7, and it's quite often where I start submissions on damages, is to simply say the settled principles is that the compensation must be received in the sum which will put the party in the position they would have been in. Interesting things arise when we have variations to the rule, and I've extracted there at paragraph 8 part of a case that arose, and there's a series of these cases in the late 80s where there must have been massive inflationary pressures. I don't really remember the time myself for that reason, but there are a lot of cases around that time that talk about the precise timing of when the damage is accrued, and it seems to have made a massive difference to the amount that you would recover. So at that point, there seemed to have been a lot of focus on when the time of the breach actually was, because that's the time in contract that your loss will accrue, as opposed to in tort, where your loss accrues at the time that your loss crystallises. You need your loss to complete the tort, and so it follows that your damage has to be calculated from that time. And once again, it's one of those things that we don't necessarily focus on, but when it comes to advising our clients about the quantum of their likely recovery or possible recovery, it's one of those things that we actually need to bear in mind. I threw in a note about risks because I think, once again, it's an area where there's potential for recovery of damages that is sometimes overlooked. And I also put it in because I really like the quote, and it really concerns issues that have come up in cases I've been in that have dealt with, for example, land valuation issues, where you've had valuation experts who come along and say the value is this, and then you have somebody else come along and say, oh, but we had an offer, or there was an offer in this amount. And so you can actually have a situation where people are arguing over an actuality or an expert's report, and which is right at which time, and what you can take into account. And I've always really liked this quote from Lord McNaughton, which basically says, why should the judge listen to conjecture on a matter which has become accomplished fact? Why should he guess when it can be calculated? With the light before him, why should he shut his eyes and grope in the dark? The word grope doesn't come up much in judgments anymore, and so it's sort of useful for that purpose, if nothing else. but it once again just demonstrates that even when we have novel arguments being put, people come back to these basic principles, and there is an element of common sense about the loss that becomes incorporated. I'm going to skip through them. I'm conscious of time, and I don't want to avoid injunctions entirely, but I'll skip down at paragraph 13. I referenced a case that I think admire would be a way of putting it, because of the evidence and the time and effort that must have been put in to getting the evidence right. It was a case that involved several hundred plaintiffs, in fact, against a financial advisor, financial advisors who had given dodgy advice, and as a result, these people had lost their life savings, and they were almost to a T conservative, risk-averse investors who were trying to create a safe and happy retirement for themselves, and they were only a few years off retirement. So you can imagine the sort of distress this caused when they discovered that all of their deductions had been disallowed, were probably illegal, and the ATO was seeking not just the money back, but penalties and remedies and all sorts of things. So they went from being reasonably comfortable and just wanting to secure their retirement to all of a sudden massive penalties and what I appreciate about this case is that it didn't just stop at the penalties. They didn't say, well, the ATO charges $200,000, so we want $200,000 from you. They said, this destroyed my life and my family interaction, my retirement, my expected enjoyment, my peace of mind. And it's from that point of view, there were clearly some good strategic decisions made early on about how to approach the question of damages in that case, because it's consistent from the beginning, and you can see the way that the evidence unfolds in the retelling in the judgment. And I had a watching brief for insurers in this, so I had the wonderful experience of just being able to watch and report and see it unfold. And you could see that discipline in how it was done, and you could see that somebody had at the beginning thought about what they wanted, and they'd gone out there and they'd gotten medical evidence about the psychiatric impact. They had statements from family members. They really didn't spare those things, and they put them before the court and said, we want you to ascribe a dollar value. And they were met with the inevitable argument, can't put a dollar value on this, it's too hard to calculate. And they went back to the principles that start off, well, classically set out in Amman Aviation, which I've footnoted in here somewhere. Even though it's hard, you have to try. And there's that wonderful little formula that judges constantly bring out. Doing my best, I calculate that damages should be in X amount. And that's precisely what Justice Mandy did. He did his best with what he had before him, and you got the overwhelming sense, and in reading the judgment you still get the overwhelming sense, that the judge was given enough to do his best, and that it was made easy for him. And so he preceded his comments with, doing my best, I calculate that X, Y, Z, and an award of reasonably substantial damages for that followed. So the end result for the clients was a very good one. They ended up not just with the amount of money that they were charged with, but they ended up with some amount, I think it was in the realm of about $50,000 per person, in respect of that distress. And given that that didn't take away from, for example, I would have invested in property and the property would have given me 13% of my investment, and the recovery of that amount was separate. So you can see that there's been real consideration about different heads of damages. I've noted exemplary damages, I understand Simon will speak about, so I'll leave those alone. I wanted to make a few notes about liquidated damages, once again because I think they're an interesting species. They're interesting because the issue about them often arises out of an attempt to simplify things. People put into their contracts, in the event that you break, crash the car that I'm hiring to you, you will pay me $50,000. And in the event the car happens to be worth nearly $50,000, well, it saves everybody some time and effort. You don't have to go and figure anything out. But if we're talking about my 1989 Toyota Corolla from when I was a uni student, your $50,000 suddenly doesn't seem quite so reasonable. And the courts are likely, let's face it, to strike it down as a penalty. So what you've ended up then with is a clause that you're trying to rely on that just creates a barrier to recovery. And the way I've put it there is in paragraph 16 and 17 is to talk about using these clauses responsibly. Now obviously at our end of things, we're litigators, so it's not really up to us to put them into the contract. We get them, and our commercial departments have put them in. But it is up to us about whether we press them. And I think that some common sense about whether to press a liquidated damages clause and basically turn your mind to, is this a genuine pre-estimate of loss? And if so, let's run with it and let's try and make this a confined question, and that gets us a great outcome. Or are we gilding lily a bit here? Have facts changed since the contract was signed? Let's engage with this question intelligently, because just because you have such a clause doesn't mean you have to use it. And we all know that to the extent that something is a clause is intended to deter breach, you're not likely to get away with it anyway. I've also put in there, just as a footnote really, even though it goes for a paragraph or two, the new consumer credit, Australian consumer law that will be coming in or might have come in, will incorporate into the new version of the Trade Practices Act concepts of unfair contracts. And I just make the note there because it's something else to keep in mind when you're considering such a clause is, I think there's a reasonable argument that in a standard form contract with an individual, leaving aside two companies, something that has a limitation on liability or a liquidated damages clause might well be the sort of thing, if it's not negotiated and not talked about, it might well be the sort of thing that gets caught in those unfair contract terms and gets excised. So you've gone from a clause that could save you time and money to a clause that just creates a whole nother fight. And who needs another fight? Except barristers. It's always good to keep an eye on barriers to recovery. Remoteness is probably the most common, causation close behind it. Once again, they're different concepts, but worth both keeping in mind. We all know Hadley and Baxendale and the first and second limbs. There's something to really think about when you're assessing your damages and you're likely and you're assessing your likely recovery. Sorry. And once again, keeping an eye on the type of evidence you can bring to bear, particularly when you're looking at the second limb in Hadley and Baxendale, and that's the special knowledge limb. Your first limb is what naturally arises, and your second limb is what do we know or ought to have known on the basis of this relationship that could lead to loss. So evidence about that early on, so you can really advise properly about those sorts of things, is really helpful. I'll skip over exclusion clauses. I think we all know to be careful. Proportionate liability, once again, I'll skip over. There's a few relevant footnotes there. I think proportionate liability is one that pops up sometimes when you least expect it. And I think the one thing that takes people a little bit by surprise is that it can pop up in contract. So we tend to think of it as a personal injury issue, but it can pop up outside personal injury and it can pop up in contract, although it really only is where the contractual term is a term to take reasonable care. So there's got to be that closeness, if you like, and you'll almost always have a tortious claim at the same time. So query, but if for strategic reasons you're running one type of claim that is under contract, be aware that you can be met with an apportionment argument in the right circumstances, or indeed that you can bring one to bear. It can be useful if you're on the defendant side. I've noted as well the Trade Practices Act and recovery under the Trade Practices Act of damages. The courts basically tell us that the Trade Practices Act isn't to follow contract or tort necessarily in terms of the principles guiding the award of damages, but they usually do. So it's good to note there's a couple of cases I've extracted there that really set out the principles that the courts have adopted, and this concept of you must show that the damage has been caused by the breach that is being complained of, and what that really means. And once again, it's all about creating the connection between the breach and the outcome. I wanted to spend a few minutes on injunctions, so I hope we're not speeding through. Do we want to stop it for questions for a second there, or we'll keep going. I'll assume that your silence is enraptured silence rather than... You have been given coffee, so... Injunctions. Now, I'll start at the end. If you go to page 10, you'll find my diagram. I enjoy diagrams. I'm a graphic thinker. And it is actually this simple, really, but there are a few issues along the way. Injunctive relief, and this is really interlocutory, injunctive relief in this diagram, is one of those things that often we need to deal with quickly, and there's often a lot of urgency and, dare I say it, panic. And it's good just to keep in mind the principles, and really if we can run through and tick off these sort of boxes, you've really got the building blocks of getting to court and knowing what you need and what you're going to get. So we can either have proceedings on foot or you can undertake to commence them, but it's got to be one of the two. You don't just run off in a vacuum. And that really follows on to the next question, is there a serious question to be tried? We all know the formulation of serious question to be tried, and it has a lot of variations on it, but basically you've got to have an argument, and it doesn't have to be the most brilliantly strong argument. It doesn't have to be the argument that's going to win, but it has to be an argument that could win. And I think we can usually come up with a serious question to be tried. If there is the impetus to go, particularly to the Supreme Court, to get an interlocutory injunction, generally there is a serious question to be tried. Balance of convenience is a little bit more difficult. Being faced with the question from the judge, well, why won't damages do the job if you're right, is probably the most annoying moment when anyone's seeking an interlocutory injunction. And I think that the court sometimes needs to be reminded that it's not all about that, and damages don't cure all. And I think the recent Aon case from the High Court, which was about case management, but it does make some useful comments about damages aren't a band-aid cure-all for everything, and you can't just say any delay will be cured by damages. And I think that's useful to remind courts about that. It is an equitable remedy, and so that's where the next little square comes in, the discretion exercised in favour of granting the injunction. That's where you get all the sorts of things that equitable principles bring to our attention coming into play there. So the sorts of things there are going to be delay, why did you wait so long, and that's why there is often the panic, and that's why there is the rush, and why it's a Friday night and you're dragging the practice court judge away from whatever convivial plans he or she had for the evening, because you can't delay. And if it is that urgent, if you do need an injunction seriously, well, you've got to get to court and get your remedy. And of course, at paragraph 44, I set these out and cited the relevant cases with lack of candour, unclean hands. We all know the sorts of things. They're the sorts of things which, on an interlocutory basis, can be a bit of an ambush. And we all know it's just important to have the right people, right instructors to answer the questions about what the story is, what we're doing here, so that you're not ambushed at the time when you stand up and say, we do have clean hands, there's nothing to bar our recovery here. And if the other side stand up and say, well, funny they should say that, what about X, Y, Z? But your CEO is off in the Bahamas at the moment and you can't answer that. It's quite difficult. So there is a matter of having your ducks in a row and just taking those minutes before you do dash off to think it through. Mandatory injunctions are interesting. There used to be a different test, a higher bar, to get a mandatory injunction. The authorities, I think, now, and I've extracted them at footnote 20 in paragraph 45, I think favour the view that the tests are the same now. Bradtoe, I think, put that to rest. But there's still, I think, a need to remind people of that. And you are still going to have a balance of convenience question, I think. I think the issue that the reason that you used to need to have a higher bar is because the courts were reluctant to make an injunction, make someone do something positive, rather than preserving the status quo, which is what a prohibitory injunction always sort of felt like. So even though you nominally have the same test, I think that you sometimes face a balance of convenience argument where the judges will have a little bit of reluctance because they feel that the balance of convenience is more easily satisfied in just preserving things rather than getting somebody to do something. The undertaking to damages is, as we know, important. It comes up again in that discretion point. It's unlikely the judge will exercise their discretion to give you an injunction, no matter how strong everything else is. If you're not willing to give that undertaking, I don't think you're going to get there. I'm not sure if anyone's ever gotten an injunction without an undertaking as to damages. Has anyone? No, I haven't heard of it happening, but so it's important once again to get those instructions to be able to give it as a matter of course. And interestingly, if you are on the side where somebody has given that undertaking and you're aggrieved by the injunction, you've actually suffered loss. It can be quite an interesting and difficult process to get that undertaking honoured in a way. And once again, that can be a real issue in terms of demonstrating the flowing of loss from the injunction itself. Once again, it's something that doesn't come up often, but when it does, it can cause real headaches. I think there's been recent High Court authority that talks about it in International Finance, which was a Confiscation Act case coming out of the New South Wales Confiscation Act in New South Wales. It dealt with constitutionality of the confiscation regime, but in that context there were some comments about the undertaking as to damages given on the basis of injunctions. So that, ladies and gentlemen, is my whistle-stop tour of Remedies. The paper's there with sort of citations, and I think you'll agree, a very funky diagram. We have about 2 minutes for questions if you'd like. Otherwise, as I understand it, we'll have coffee for 5 minutes before Simon regales you. I'm delighted to have been able to cover your issues so comprehensively that there is not a question. So thank you all very much for your attention.